All right, everyone, just give me a moment, please. Nathaniel Navy, you're back.
Yes, Judge.
All right, and who is your client?
Rocky Marios.
Okay, and is Rocky Marios in the courtroom still?
Yes, Judge, he is.
All right, do you know, Nathaniel, has your client signed all his paperwork?
Yes, Judge. Yeah, we've signed everything now.
All right, just give us a moment.
No problem.
All right, who is the attorney on Nathaniel Navy's client, Rocky Marios, who's wanting to handle the plea?
I will be, Judge.
All right, we're going to take that up.
Ready for this?
Yes.
All right.
Nathaniel, I think we're going to have to start making you like co-host or something.
I wouldn't want that responsibility, Judge.
We're going to give it to you anyway. We see you, I think you're here like every other day.
Yeah.
All right. The court is calling 2019 CR 12201, State of Texas versus Rocky Marios. Could I have parties announced for the record, please, for the state,
Kelsey Leslie for the state of Texas.
for the defense?
Nathaniel Navy, Your Honor.
And are you Rocky Marios?
Yes, I am, Your Honor.
Okay, how do you pronounce your last name? Because I know I keep pronouncing it different every time I say it.
No, you're fine, Your Honor. It's Morillos.
Morillos. Okay,
Yes,
I'll try to roll my R.
That's good.
All right, we're proceeding by video. Any objections from the state?
No objection, Your Honor.
Any objections from the defense?
No, Your Honor.
Court will note that Mr. Morillos is in the courtroom, but Mr. Morillos, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, I did, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case and did you review that discovery with your client?
Yes, Your Honor, we did.
Court will find that the state is in compliance with discovery. Are there any applications in this case or no?
No, Your Honor.
Mr. Morillos, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, I did, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we waived the reading.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state has a motion to reduce this offense to a Class A misdemeanor of deadly conduct.
No objection, Your Honor.
All right, and it's the state, I'm assuming the state is waiving the repeater offender enhancement allegation.
Yes, Judge.
Any objections?
No, Your Honor.
Mr. Marios, I'm going to show you what's entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, I did, Your Honor.
Did you understand the state is proceeding on the lesser included offense of deadly conduct as a Class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
I did, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, I did, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Marios, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am, Your Honor.
Are you a U.S. citizen?
Yes, I am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney, and did you understand it?
I did, Your Honor, and I do understand.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of deadly conduct as a Class A misdemeanor. They're requesting that your punishment be assessed at 180 days in the Bexar County Jail. There's a $2,000 fine, and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, I did, Your Honor.
Defense is at the plea bargain agreement.
Judge, I discussed this with the state and there was going to be no fine on it. We just asked if somebody could mark that out and make it a $0 fine.
That was my mistake, Your Honor. It is a $0 fine.
Mr. Marios, do you understand that according to the plea bargain agreement, there's to be a $0 fine, not a $2,000 fine? Did you understand?
I did, Your Honor.
Then did you understand that to be the entirety of the plea bargain agreement?
Yes, I did, Your Honor.
Defense is that the plea bargain agreement?
It is, Judge.
State is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it in both places?
I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did understand, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then, Mr. Marios, to the lesser included offense of deadly conduct as a Class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's no contest plea.
State moves to enter State's Exhibits 1 and all of its attachments.
Any
No.
objections?
No, Your Honor.
Mr. Marios, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, I did, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, I did, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty of deadly conduct. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I would just ask that you follow the agreement. Mr. Marios has been working. He's been employed. He has a newborn child, Judge, that's been in the NICU. He's been trying to work and take care of his child. And he knows that he's going to have to do a little bit of time in the county jail, but just wants to put this behind him and move forward with his life. And I would just ask that you follow the agreement that I've reached with the state of Texas.
All right, the court will follow the agreement, sentence you to 180 days in the Bexar County Jail, give you credit for any time served. Is there going to be an affirmative finding of family violence?
No, Your Honor.
State would request an affirmative finding.
Was this something that you all had discussed? Because from reading the report, the complainant in the case is his wife / girlfriend / fiance.
It was something that we had not discussed, Judge. It hadn't come up. And I assume just being a deadly conduct, that was not something that the state was going to seek.
Well, Mr. Marios, if you wish to speak with your attorney, you can, but with an affirmative finding of family violence, you're not allowed to own or possess any weapons. And you're also not allowed to be designated as primary custodial parent. So do you still wish to go forward?
I'm a little lost here because I was never told any of
Just
us.
1 moment. Let me send you to a breakout room with your attorney.
Yes, ma'am. Thank you,
I'm
Your
gonna
Honor.
send you, you're welcome. I'm going to send you to breakout room number 2. And if the courtroom could go to 2, please.
Thank you, Judge.
You're welcome. Everyone, just give me a moment, please. Jackson Lindsay.
Yes, Judge.
Yes. What is happening with your client,
Well,
Lopez?
we took a plea at least a couple weeks back, waiting for placement in lifetime recovery. I just spoke with him about it. He's not heard anything on the advancement of that. And so I think that's where we're at.
All right, Rebecca,
Yes, ma'am.
Do you know where Mr. Lopez is supposed to be placed?
Let me check his file.
All right, thank you. Because I have lifetime recovery / Crosspoint. And I don't know if Crosspoint has been contacted or not. And Mr. Navy, is your client going to go forward?
Yes, Your Honor, we'll still go forward with it.
Okay. All right, and Rebecca, while you check on that, I'm going to go back on the record on Mr. Murillo's case. All right, we're back on the record in 2019 CR 12201. Mr. Murillo's, because it wasn't a part of your plea bargaining agreement that there will be an affirmative finding of family violence. I want to go over some more instructions with you so that we can have the record clear. After reviewing States Exhibits 1 and attachments, the court is finding that there is an affirmative finding of family violence. With an affirmative finding of family violence, what that means collaterally is that you are not allowed to own or possess any weapons or ammunition. Do you understand?
I do, Your Honor.
And you're not allowed to be designated as primary custodial parent. Do you understand?
I do, Your Honor.
Knowing that, do you still wish to go forward with the plea bargain agreement that was reached between your attorney and the state?
I do, Your Honor.
All right, is there anything else that you need to put on the record, Mr. Navy?
No, Your Honor.
State, anything else that you need to put on the record?
No, Your Honor.
All right, then the court will follow the plea bargain agreement that's been reached. The court will find there's sufficient evidence to find you guilty of deadly conduct. The court will sentence you to 180 days in the Bexar County Jail, give you credit for any time served, and there's an affirmative finding of family violence. Is there anything else from either side with regards to sentencing?
No, Your Honor.
No, Your Honor.
Next, Mr. Murillo's, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
I did, Your Honor, and I do understand.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do, Your Honor.
And also because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am. Yes, I do, Your Honor.
All right, with that, we can go off the record. Mr. Murillo's,
Yes,
this child that you have, is this the child that you have with the complainant?
yes, Your Honor.
All right. So, Mr. Murillo's, here's the thing. When you're in relationships, people can say and do things that make you angry or upset. It's best to walk away. You're not allowed to put your hands on anyone in anger. Do you understand?
I do, Your Honor.
And the other thing, I don't know if you were being unfaithful or cheating or not. But next time, maybe you don't want to leave your smartwatch behind, because text messages do come over that.
Yes, Your Honor.
When I was growing up, all you had to worry about was the landline. And then they started where you could leave messages, and hopefully no one would leave a message saying, I'm the person you're cheating with, give me a call back. But that's neither here nor there. You've chosen to be in a relationship with your wife. My advice to learn patience, because you're not taking the BIP course. Brenda, what do I tell everybody? Get an orchid. Keep that orchid for a year. And if it blooms, you have patience, you're ready for a relationship. And I say that because orchids, you can't move them around too much. When you do move them, you have to be gentle with them. No matter what instructions they give you for an orchid, be it this amount of sun, that amount of sun, it never works. But you have to have patience. You understand?
I do understand, Your Honor.
And now that you have a young child, you're going to need patience by the handful. Children learn by doing what you do. That's how children learn how to talk. If you use profanity in your house, the first words your child is going to learn is profanity. If you are abusive to their mother, because this child you have, is it a girl or a boy?
It's a boy.
All right, so here's the thing. If you're abusive to your mother, you know what your son's going to learn? That's the way you show love to somebody, by being abusive. And that repeats the cycle. If you have any girls, guess what? They're going to think that their husband or their boyfriend loves them because they're abusive to them, because that's what they see their father doing. So you had better stop that, because otherwise you're going to find yourself in and out of the Bexar County Jail or in and out of prison. You understand?
I do understand, Your Honor.
All right, they're going to take you into custody. Good luck to you.
Thank you so much, Your Honor.
All right, you're welcome.
Thank you, Judge. May I be excused?
Yes, and we'll see you tomorrow, Nathaniel.
Thank you, Judge.
I don't know if that, you're welcome, Nathaniel. I don't know if that's true or not, but I think you're gonna see for
It's not.
yourself.
I didn't know if you were referencing a specific case that I was like thinking that I had forgot about, but yeah,
Yeah, and we'll probably see you tomorrow.
scared me a little bit there.
Okay, have a good rest of your day.
Thank you, you too. Bye.
You're welcome. So Jackson, Lindsay, Mr. Lopez.
Yes, Judge.
Yes.
Waiting
Judge,
there.
it looks like, it doesn't look like the referral was made for a lifetime.
All right, can we get that done?
Yes, ma'am. I can go into a breakout room with him and get that paperwork started and submitted.
All right, so Mr. Lopez, there was a slight miscommunication. We're going to take care of that. Lifetime does have openings, because I've recently spoken to the person who's over Lifetime. So they do have openings. If something happens and they magically filled up, then I definitely know Cross Point has openings as well. So Norma, on Mr. Lopez, can we recall this in 2 weeks, please?
Yes, ma'am. I can do August 2nd.
All right, so we're going to come back on August 2nd just to make sure that you've been transported, Mr. Lopez. If you've been transported, we're not going to have the hearing on August 2nd, okay?
Thank you, Judge.
All right, you're welcome. Thanks for your patience. Mr. Lindsay, Mr. Lopez, I'm going to send you all to breakout room number 1, and Rebecca will meet you there.
Thank you, Judge.
All right, is there any, Bill Davidson? Bill Davidson.
Yes, Your Honor. I was just trying to unmute it. I'm sorry.
Oh, that's okay.
I have the MTR paperwork that I signed, and so it should be en route to probably my client to sign, or somebody
All
else.
right, Mr. Martinez, have you signed paperwork?
No, ma'am.
All right, did you receive any paperwork on your end?
No, ma'am.
All right, Norma, can you have one of the deputies see if Mr. Martinez has paperwork to sign?
Yes,
All
ma'am.
right, and so Mr. Martinez, what I'm going to do, I'm going to send you to breakout room number 3. Mr. Davidson, if you'll go to number 3.
Okay, thank you.
And someone will meet you there to make sure we have the paperwork. And then the other person who's up now is on RC Curtis. Who are the parties on Mr. Curtis?
Judge, I'm here on behalf of the state. Daryl's in the other room. I can go grab him. Just one moment.
Okay, if you want to, yes. Charles Black.
I'm here, Judge.
Okay, we're going to take up your matter in just a moment.
I don't know if Mr. Languaz was able to join us or if he's, but I'm comfortable. I've been in contact with him and he understands what we're doing.
All right, and are you okay with proceeding without Mr. Langlois?
On this matter, I am, Judge, yes. I mean, as long as the court is, understanding I'm the second chair. But I've
well,
been in contact with him. I've told him I was going to file this motion and have, and he's in agreement with me on this motion. So
okay, just give me one moment. Everyone, just give me one moment. Mr. Curtis, I'll be right.
Surely will.
Okay, Brenna, are you ready on Mr. R.C. Curtis?
Yes, Judge.
Okay.
Did they bring you back? Were we in the private room first?
All right, Stephen Spear and Daryl Harris, you all are in the shadow like this is, you're in a witness protection program or something?
I can make them.
Yeah, so if we could get some light.
I said the same thing.
Here, Judge, there you go.
All right, thank you.
All right, much better.
All right, the court is calling 2019 CR 10230, State of Texas versus R.C. Curtis. Could I have the parties announced for the record for the state,
Daryl Harris and Steve Spear for the state, Your Honor.
for the defense?
Charles Bunk on behalf of my client, R.C. Curtis, who was also present via Zoom conference.
All right, and are you Mr. Curtis? Could you unmute for me? Yes.
Yes, ma'am.
All right, we're proceeding by video. Any objections to us proceeding by video, state,
No, Your Honor.
defense?
Not for the purpose of this matter, no.
Mr. Curtis, you have any objection with us proceeding by video?
No, ma'am.
All right, the first chair defense attorney on this case is Richard Langlois, is that correct?
That is correct, Judge.
All right, Mr. Bunk, are you proceeding without Mr. Richard Langlois, and is he aware of this hearing?
He is aware that the motion was filed. I tried to reach him this morning to ask him if he was going to be at that. I haven't heard back from him. But he knew the motion was, I asked him, actually, he is out of the country. I just got a message. But I'm prepared to proceed on this hearing without Mr. Langlois present. I don't want to wait. In other words, I don't want to wait until he's back because I believe time is of the essence for this honorable court.
All right, Mr. Curtis, do you have any objections to us proceeding with just Mr. Bunk?
No, ma'am.
All right, Mr. Bunk has filed a motion for continuance. State, have you had a chance to review that motion?
Yes, Your Honor. My co-counsel has.
Yes, yes, Your Honor.
All right, State, are you ready to proceed?
We are, Your Honor.
All right, defense, it's your motion for continuance.
Your Honor, on behalf of Mr. Curtis, Mr. Langlois and myself filed a motion for continuance. I believe it was filed on the 7th of July. And it's in the body of the motion, it states, and I would reiterate what's in the motion. It was brought to my attention that roughly, and within the last 2 weeks, a witness who had been missing, last name Rocha, for the record, R-O-C-H-A. Mr. Harris informed me that Mr. Rocha had been taken into custody by the U.S. Marshals. I believe it was in Miami, Florida. Mr. Rocha was then transported from Florida to the Bexar County Jail as a result of that. Since he's been here, it's been indicated to me he has an attorney he hired. I think the court is aware of that, and the court may or may not have spoke to his lawyer regarding this matter. And then within the last week, as I understand it, Mr. Rocha had a chance to be interviewed for the first time by the Bexar County District Attorney's Office. Mr. Harris has indicated to me he expects that there will be, while there was no sworn statement taken, he had a very long, I guess you would call it a debriefing with the district attorney's office. And Mr. Harris has indicated to myself that he is going to give us, I guess, a copy of either his notes or a summary, hopefully a very detailed summary of the conversation that that Mr. Harris had with this witness, Mr. Rocha. In discussing with Mr. Harris the generalities of this statement, there is a considerable amount of new information that was not available to the defense prior to Mr. Harris calling me. I believe it was last Wednesday or Thursday of last week when Mr. Harris was kind enough to call me and let me know what was going on. But nonetheless, because of the volume of this new evidence, some of the evidence, I believe, one of the things, for example, is that this witness told the state about another witness who says he was present when this murder happened, and that's completely new to us. So in additional to that, they have taken a buccal swab from this Mr. Rocha guy that is going to be submitted to the Bexar County Crime Lab for testing. And then, of course, as the court's aware, we have a DNA expert as well who would want to review these tests. So in a case of this importance, for the record, as the court is aware, Mr. Curtis is facing the potential of life without parole, since this is the capital murder case where the state does not seek the death penalty. I cannot think of a case more worthy of a continuance in this instance because, like I said, newly discovered evidence that has, as of right now, not yet been provided to the defense for discovery. Our investigators have to investigate these new allegations. We need to try to contact these new witnesses that were not mentioned as potential witnesses prior to last week. We just cannot proceed and do Mr. Curtis's case in the manner he deserves to have his case presented by the 22nd of July. I apologize for my lengthiness.
State.
And Your Honor, just for in balance, I agree with everything that Mr. Bunk has represented. I can add some clarity. The witness who had been identified in previous reports as David Rocha, had been a fugitive since a time period of November 6, 2015, until he was returned to Bexar County custody on June the 10th, 2021. Because of protocols and procedures with someone going into the facility coming out of state, we were not able to meet with him and his attorney until Friday, July the 2nd, 2021. And at that time, the witness, in the presence of his attorney, did agree and provided the state a voluntary buccal swab. That was transferred to the Bexar County Crime Lab that day, Friday the 2nd. Mr. Spear and I met with the analyst on Tuesday, July the 6th. That day, she relayed to us that she was still working to develop a profile of the submitted sample. She anticipated about 2 weeks before that would be complete. In addition, while we got a proffer from this witness on Friday, July the 2nd, I can't take the next step to formalize a statement until this Wednesday, the 14th, is the next step. We have, out of an abundance of caution and observance to Mr. Curtis's rights, orally briefed Mr. Bunk and Langlois about the developments. So all of that is accurate, Judge. And with that, and understanding specifically as it pertains to the buccal swab and the DNA, that defense does have should be entitled to have their expert review the state's work. The state understands and does not object to defense's expert in that basis. Because of the importance of the court is well aware of everything we had to go through with the suppression hearing, et cetera, before to get here. And so that is what I believe is our position, Your Honor, that's the accounting and the record for when all of this became available.
So here's the question. Is the state objecting to the defense motion for continuance?
No, Your Honor.
All right, motion for continuance is granted. Next question. When is this statement from this Mr. Rocha person going to be ready for the defense?
Your Honor, we expect it to be, should be by Friday of this week. I have we have a polygraph scheduled on the 14th, and we are working to bring all of this to a close.
All right, the statement from Mr. Rocha is due to the defense on July 16th.
Judge, if I may also, what can I also get all the polygraph, the pre-test questions and all the questions and the resulting answers from the polygraph exam?
When is that going to be completed, State?
Should be completed on the 14th, Your Honor.
All right, that's to be given to the defense by July 20th. When is this DNA going to be completed?
The best estimate that Ms. Pomykal could give me, Judge, on Tuesday the 6th, she anticipated a minimum of 2 weeks. And that's the best I can tell you, Judge.
And that's from the 6th of July?
Yes, ma'am.
All right, that needs to be turned over to the defense by August 9th. How long will your expert need defense?
I would say at least 30 to 60 days.
Norma? You're
Yes.
on mute.
Yes, ma'am.
Can you set Mr. Curtis for trial in October?
Yes.
And Norma, if it's better for you, once we're finished with this, while we have Mr. Spears and Ms. Harris, maybe we can all sit down with your calendar and try to find a date that's mutually acceptable.
Yes, sir.
That's all I have, Judge. I appreciate your time on this matter.
Yes. Oh, no, we're not leaving until we get a trial date.
Okay.
Yeah.
Do you want us to break out with Norma and talk to her real
Yep.
quick and come back?
Yep. And Norma, it needs to be sometime in October.
Judge, the only thing I have open in October, I can tell you right now, is October 15th. That's the only date I have that they gave us.
Well, we're going to put them down for October 15th. Let me send you all to breakout room number 1. But generally, Norma, it's in the month of October, because if another judge has a jury that's available in the month of October, we're doing this in October, even if it's not on October 15th. So I'm going to send everybody to breakout room number 1.
Okay.
And we will see where we are. And so Norma, if you could go to number 1, please. And everyone, we will be right back.
Miss Brenna, how you be?
Good, how are you?
Living the dream, man. Living the dream.
Okay. All right, we are back on the record. All right, so these are the deadlines. These deadlines will be followed.
You get them all down.
The statement that the state obtained from Mr. Rocha is due to the defense no later than July 16th. The polygraph questions, the results of the polygraph are due to the defense no later than July 20th. The DNA that's tested and the results of that are due to the defense no later than August 9th. And my understanding is that all parties have had a chance to confer over a jury trial date. Is that correct, State?
Yes, Your Honor.
Defense?
Yes, Judge.
And my understanding is everyone has agreed to a November 1st jury trial date. Any objections from the state to November 1st jury trial date?
No, Your Honor.
Defense, any objections to November 1st jury trial date?
No, Judge, not on behalf of myself. With the understanding Mr. Langlois is not present in today's hearing, but I mean, I can't speak for Mr. Langlois, but for myself, no, I have no objections.
All right. When is Mr. Langlois coming back?
The 18th. My message was he'll be back on the 18th.
Norma, recall R.C. Curtis for the 18th, please.
Yes, ma'am. Do you want me to call his office right now, Judge, to see if he has anything scheduled? I can give him a call right now.
All right. Thank you, Norma.
Yes, ma'am. Give me 1 second.
Okay, so the next the contract will be submitted to it's travel costs now. A little more expensive.
All right. And we're not on the record yet, Brenna, but State, is there some sort of agreement with the witness you have?
At this time, no, Your Honor. When I get the polygraph, et cetera, we'll make that decision then. My understanding, it's one of the reasons I'm going through it, we would be presented to the court if we do.
All right. So I'm sorry, what date is the polygraph going to be done on?
The 14th, Wednesday.
Yes, ma'am.
Excuse me.
Judge,
Yes,
I just spoke with his secretary or his legal assistant. She said there's nothing on his calendar, so he is cleared for that day.
There you go.
all right. So any objections, defense, to the November 1st jury trial date?
No, Judge.
All right, so jury trial will take place on November 1st. Mr. Curtis, do you have any objections to the jury trial date of November 1st?
No, ma'am.
All right, so that'll be on November 1st at 9 a.m. You will be brought over, dressed for jury trial.
Okay.
The next issue is, state, you haven't, I guess, made the decision on whether or not there is going to be some sort of an agreement reached with the witness. Is that correct?
I have not decided, Judge. We expect to resolve that matter commensurate with the polygraph, except by the end of this week. And my understanding that if I do, that needs to be presented to the court as well.
All right, Norma, on Mr. Curtis, we're going to recall this on July 30th. Will you know by then if there's an agreement that's going to be reached with the witness, state?
Yes, ma'am.
All right, Norma, if you can recall Mr. Curtis for July 30th, and you could set it in the afternoon, please.
Yes, ma'am.
All right, is there anything else that we need to take up? State, anything else?
No, ma'am. No, Your Honor.
Defense, anything else?
No, Judge.
All right, I'll see you all back on July 30th so that we can make sure that this defense has everything they're entitled to.
Thank you, Judge.
All right, thank you all. See you then. Do you need to speak with Mr. Curtis, Mr. Bach?
I'll talk to him briefly, yes.
All right, and we're off the record, state. Next time when you have your video on, if you have the lights coming from the back, it puts you like in the witness protection program.
I might need that sometime, Your Honor.
That can be advantageous.
All right, bye-bye. All right,
take care.
Mr. Thank you. Mr. Curtis, I'm going to send you to breakout room number 2, and your attorney will meet you in 2, and we will see you back here again on July 30th, okay?
Yes, ma'am.
All right, and Mr. Bach, when you finish speaking with Mr. Curtis, just let us know so that he can be removed from the room.
Yes, Your Honor. Thank you.
You're welcome. All right, anyone else ready? Bill Davidson?
Yes, Your Honor. I think we have the paperwork all done. I'm not sure where it is, but.
All right.
Judge, I need to talk to Mr. Davidson just real quick.
Sure. I'll send you to breakout room number 4. And to the clerks, do you have the paperwork on Mr. Martinez?
No, Judge, not yet, Judge. We'll double check right now.
Judge, can I see you in a breakout room?
Sure. You breakout room number 1.
Okay.
Norma, if you're the host, Mr. Curtis is finished.
Thank you.
Bye-bye, everybody.
See, Judge, you there?
She's in a breakout room.
Oh, okay. I guess Norma, can Mr. Davidson's client go into the breakout room with him? He's in 4.
I don't have that. I don't have that.
I can assign him, but I can't like tell him.
Oh. Can he hear you? Mr. Martinez, do you know how to go to breakout room number 4? Oh, did he leave?
Yes, looks like he went. Cool.
Okay.
All right, are you guys ready on Mr. Martinez?
Judge, I think Mr. Martinez went to the breakout room with his attorney real quick.
All right. And what is happening with Bobby Gebbia and Mr. Shepherd? Does anyone know?
Extended an offer, Judge, but is he back on? I don't see him.
All right, Norma, can you get Bobby Gebbia in here, please?
Yes, ma'am.
Thank you. And Marcus Sanders.
Yes, Judge.
Hi, on the case from yesterday with John Coombs. He filed the motion and I've signed it. It's, what was that person's?
Oh, yes.
So
Yeah.
I've signed it. So I don't know if you want to go to the breakout room to talk to the clerk so they can put it in the system. And then that case can be taken care of.
Okay.
All right. So clerks, if you'll go to breakout room number 3, please.
Yes, Judge.
All right. Bill Davidson. Hello, are you ready to proceed on your client?
Yes, Your Honor.
All right, thank you. Who's the prosecutor you're dealing with?
He said he had to step out for just a minute, but he'll be right back.
He's walking right in, Judge.
Oh, okay. No problem.
Hello there, Judge.
Hi. All right, the court is calling 2016 CR 7588, State of Texas versus Ernest Martinez. Can I have parties announced for the record for the state,
Hunter Morris.
for the defense?
William Davidson.
And are you Mr. Martinez?
How are you doing, Honor?
Doing great. Are you Mr. Martinez?
Yes, ma'am.
All right, we're proceeding by video. Any objections from the state?
No, Judge.
Any objections from the defense?
No, Your Honor.
Mr. Martinez, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Enter a Deferred Adjudication. I'm sorry, Motion to Revoke Deferred Adjudication.
True.
No, just give me a moment. Brenda, it's been Monday, like really, really Monday. All right, so what I'm showing you is entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
right, are you the same Ernest Martinez Jr. who was placed on deferred adjudication in 2016 CR 7588 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on May 30th, 2017 for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state.
In Bexar County, Texas, the defendant, Ernest Martinez Jr., did then and there failed to report to the supervision officer in person for the months of May of 2018 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Say we waive and abandon the remaining allegations.
All right, any objections?
No objections, Your Honor.
All right, Mr. Martinez, did you understand by pleading to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
True.
No. Do you still wish to plead true to violation of condition number 5, knowing that I could grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor. True.
No. The answer is either yes or no.
Oh, yes, Your Honor.
Do you understand that by pleading true to violation of condition number 5, I could find it true? Do you understand?
I do, Your Honor.
Do you understand that I could also sentence you to 2 years in the state jail facility?
I do, Your Honor.
Do you also understand I could sentence you up to a $10,000 fine?
I do, Your Honor.
Knowing all of that, do you still wish to plead true to number 5?
Yes, Your Honor.
All right, the court will find violation of condition number 5 true. Is there an agreement?
Yes, Judge. We ask for revocation, adjudication of guilt, and punishment according to 1244 of the Penal Code, 100 days in the Bexar County Jail. And it's the state's understanding that the defendant has credit to satisfy the 100 days.
Is that the agreement?
Yes, Your Honor. I believe time and money run concurrent, and I believe the judgment satisfied from what I understand.
All right, Mr. Martinez, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
Court will follow your agreement. The court will grant the motion, find you guilty, sentence you to 100 days in the Bexar County Jail under 12.44 of the Penal Code, give you credit for any time served. The court will show that the judgment is satisfied. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand, Your Honor.
And also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
I understand, Your Honor.
All right, with that, we'll close the record. Mr. Martinez, you didn't do very well on your probation. It's pretty easy to report. You understand?
Yes, yes, ma'am.
If you have a drug problem, there are plenty of places that are free where you can get help for your drug problem. If you don't get help for your drug problem, one or two things are going to end up happening. Either you're going to be in and out of the Bexar County Jail or in and out of prison, or either somebody is going to make a drug because you don't know what you're taking. It's not FDA approved. You're going to take some drugs and you could end up dying. Do you understand?
I understand, Your Honor.
All right, Mr. Martinez, good luck to you. I wish you well.
Thank you so much.
All right, you're welcome. Norma, can you let them know that Mr. Martinez can go back? He doesn't have a seat number.
Yes, ma'am.
All right, and can you also let them know that Curtis can go back?
Yes, ma'am.
All right, thank you.
And be excused, Your Honor.
Yes, thank you, Mr.
Thank you.
Davidson.
Thank you.
Bye-bye. All right, the only person we're waiting for is Bobby Gebbia.
And Judge, we were not able to get in contact with the compliance hearing gentleman.
Okay. And that is,
It wasn't on there. It was Roper McDonald.
all right, can you send me the information on him so I can make a decision then?
Yes, ma'am.
Thank you. Mr. Shepherd, we'll be right with you. Your attorney should be zooming in.
Okay, do I need to call him?
I mean, yes, you can call him if you would like to.
Okay.
Thank you.
He had just texted me.
All right, thank you. And Rebecca, I sent that document that you wanted me to sign. It should have gone through.
Okay.
Oh, I'll tell him.
I've already signed it.
Yeah, Marcus is gonna send you.
Okay. All right, thank you. And Norma, I have a file on Joshua Alexander Rizzo Lira. Do you know why I have this file? Because he's not on the docket. I'll put the cause number in the chat box.
Yes, ma'am. Thank you.
right, Bobby, have you had a chance to confer on Mr. Shepherd's case?
Yes, I have, Your Honor.
All right, what is happening with Mr. Shepherd?
We have an agreed recommendation to the court on his MTR.
All right, have you all filled out the paperwork with Ms. Ferguson, or is this going to be a withdrawal? Is he pleading to anything?
No,
He
it's
is
an
gonna
agreed-
plea.
It's a plea of true and an agreed recommendation.
Okay, then you'll need to get paperwork from Ms. Ferguson, and she'll need your client's email address.
Okay, no problem.
Rebecca, I sent you a chat. I just wanted to clarify something really quick.
Let me check it out.
Marcus Sanders, are you there?
Hey, Judge, he and I were just texting, actually.
Okay, awesome.
Yes, Judge.
All right, so John Coots is here on Mr. Alexander Gill.
Yes.
So
I
I'll just,
submitted the dismissal to you and the rejection.
okay.
And thank you again, Marcus. I appreciate it.
And no problem.
Okay, what I have is, okay, this is what I have. The dismissal, let me see you all in the breakout room.
Fine, be that way.
Yeah, I am. So if you guys can come to breakout room number 1, please. All right, are we ready on Mr. Shepherd, Mr. Gibbia? Who is the prosecutor on this?
We are ready, Judge.
Me, Your Honor.
Thank you.
Do you want to pre-trial the officer?
All right, the court is calling 2020 CR 2544, State of Texas versus Victor James Shepherd. Can I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
Good afternoon, Your Honor. Robert Gebbia for Mr. Shepherd.
And are you Mr. Shepherd?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Shepherd, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand it?
Yes, ma'am.
Are you saying Victor James Shepherd, who was placed on deferred adjudication for possession with intent to deliver a controlled substance, penalty group 2, 4 grams to 400 grams on October 22nd, 2020 for a period of 4 years? Is that you?
Yes, ma'am.
Right, state?
One moment, Your Honor. Okay, violation condition number 2. On or about the 23rd day of October 2020 in Bexar County, Texas, the defendant, Victor James Shepherd, did then and there illegally use marijuana in violation of condition number 2.
How do you plead to that, true or not true?
True.
State?
They will be reading from violation condition number 5. In Bexar County, Texas, the defendant, Victor James Shepherd, did then and there fail to report to the supervision officer as directed for the months of December 2020 and February 2021 in violation of condition number 5.
How do you plead to that, true or not true?
True.
We'll waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
All right, so everyone, the judgment for this case is not correct because this is a second-degree felony. Is that correct?
Penalty group 2, Judge, so it might even be a third.
I think it may be a second. Just one moment.
Let me pull up the judgment, Judge, because in here it says with intent to deliver.
Okay. But I can tell you it's listed in the court admonishments as a second degree. In just one moment, let me check the code.
Looks like penalty group 2, 4 to 400 with the intent to deliver is a first degree.
First degree. But for some reason,
The paperwork says possession.
yes,
Probably proceeded on count 2 only. Been a little while since we've done the plea, but we probably proceeded on count 2 only. But I don't have any notes on that here.
yes, we did proceed on count 2 only. So the judgment is incorrect. So,
Dismiss the whole thing.
so we just need the judgment to be corrected. Julie, I'm going to put the information in, and cause number 2020 CR 2544. The judgment is incorrect. They should have proceeded on count 2. And actually it does say count 2 on the judgment, but they still went with possession with intent to deliver. So it should just be possession.
So the only needs to be changed as opposed to possession with intent to deliver to possession.
Yes, and then it should be a second degree felony in the judgment.
And right now they have it as a third degree enhanced. They have it as a first degree.
They have it as a first degree.
Okay. Okay.
All right, thank you.
And okay, I will work on that. Thank you.
All right, and then
Then I guess I can orally amend the MTR.
Is there any objection to the oral amendment to the motion to revoke?
No, Judge.
That would just read possession as opposed to with intent to deliver.
Yes.
Okay. I will work on.
All right, so we are going to go back on the record, Brenda, and we're just going to start over. Court is calling 2020 CR 2544, State of Texas versus Victor James Shepard. Can I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
Robert Gebbia.
And you're Mr. Shepard?
Yes, ma'am.
All right, any objections to us appearing by video? State,
No, Your Honor.
defense?
No, Your Honor.
Mr. Shepard, you signed a document entitled Defendant's Consent to Appear by Video Conference, and you electronically signed that document. Did you have a chance to review it with your attorney, and did you understand it?
Yes.
All right, the court will find that defendant has knowingly and voluntarily consented to appear by video. Are there any motions from either party with regards to the motion to enter adjudication of guilt and revoke community supervision?
Yes, Your Honor. The state moves to amend the motion to enter adjudication of guilt and revoke community supervision and strike the language of with intent to deliver in order to properly reflect the judgment.
All right, any objection?
No, Your Honor.
All right, then Mr. Shepard, I'm going to show you documents entitled Motion to Enter Adjudication of Guilt and Revoke Probation and State Supplemental Motion to Enter Adjudication of Guilt and Revoke Probation. Did you review those documents with your attorney and did you understand them?
Yes, ma'am.
With the oral amendment, are you the same Victor James Shepard who was placed on deferred adjudication in 2020 CR 2544 for the offense of possession of a controlled substance, penalty group 2, 4 grams to 400 grams on October 22nd, 2020 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 2, on or about the 23rd day of October 2020 in Bexar County, Texas, the defendant, Victor James Shepard, did then and there illegally use marijuana in violation of condition number 2.
How do you plead to that, true or not true?
It's true.
State.
In Bexar County, Texas, the defendant, Victor James Shepard, did then and there failed to report to the supervision officer as directed for the months of December 2020 and February 2021 in violation of condition number 5.
How do you plead to that, true or not true?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Shepard, did you understand by pleading true to violation of conditions 2 and 5, the court could find it true grant the motion, find you guilty and sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 2 and 5?
Yes, ma'am.
Court will find violations of 2 and 5 true. Is there an agreement?
Yes, Your Honor. The agreement is to ask this court to deny the motion, continue him on his deferred adjudication, alter and amend his conditions to include 60 days of GPS monitoring, 60 days of weekly testing, a TAP evaluation, because I believe it never was completed, and to follow the recommendations of the TAP evaluation.
Is that the agreement?
It is, Your Honor. The only thing that I would ask is that Mr. Shepherd be allowed to work while he's on the GPS monitoring.
Any objections?
No, Your Honor, with proof of employment, because I don't think that was ever submitted either.
Mr. Shepherd, if you're drug tested today, what are the results going to be?
Come out positive.
What for?
Marijuana.
All right. And the other thing is, why didn't you show up for your compliance hearing on March 1st?
My son was being born. He was born March 16th, and my son's mother was admitted into the hospital.
So you don't have a telephone? Do they not have telephones in this time and age that we live in?
Yes, we do, but I was more concerned of my son and my son's mother's health because there was a emergency section.
So that's March 1st. Did you contact your probation officer? Let me see the calendar. March 2nd,
No, ma'am, I didn't.
March 3rd,
No, ma'am, I didn't.
March 4th,
No, ma'am, I didn't.
March 5th,
No, ma'am, I didn't. She was,
the week of March 8th.
my son was born on the 16th, so she was in the hospital for a few weeks.
All right. Did you contact probation on April 6th?
No, ma'am.
The week of April 12th?
No, ma'am.
The week of April 19th?
No, ma'am.
The week of April 26th?
No, ma'am. I don't believe so.
All right. Did you contact them in May?
I remember talking to her prior to me having my gallbladder removed because she's the one who gave me the instruction to go to the university hospital.
All right. So, and what's up with the glove on your hand?
I do tattoos. I was drawing. I was painting.
All right. See, here's my thing. I don't know if you're serious about this probation.
Yes,
Because
ma'am.
you're smoking marijuana and you come to me and your child actually, you're not a good role model at this point in time because you're smoking marijuana and you're still smoking marijuana. And you're telling me, I'm assuming your child wasn't able to come home from the hospital right away, or was he or she?
He wasn't.
All right. So is your child living with you?
No, ma'am, he's not.
And why is that?
Because me and his mother are separated. We're on a court order.
All right. Is Child Protective Services involved?
No, ma'am.
Do you have a job?
Yes, ma'am.
What do you do?
I am a parking attendant for a parking lot at a club.
All right. When's the last time you used marijuana?
When I got arrested for the MTR.
When is that?
It's been about 2.5 weeks now, I believe.
So do you live with anyone or do you live by yourself?
Well, now I live with my mother.
What are the hours you work?
I work from 9 to 5, 9 p.m. to 5 a.m.
All right, this is what the court is going to do. There's going to be 60 days of GPS. The defendant is allowed to work upon proof of employment. I'll ask that the GPS fees be waived or either he be placed on the indigent status list. there is to be intensive outpatient treatment with probation. I'm going to want him tested for levels. The defendant will be allowed to work while on GPS upon proof of employment. There's to be no employment with minors or as a healthcare provider. Parenting classes, there's a curfew of 7 p.m. unless he's at work. Is there anything else from either side?
Not from the defense, Your Honor.
All right. Anything else you need, Mr. Shepherd?
No, ma'am, I really appreciate you. Thank you for doing what you do.
All right. Mr. Shepherd, let me explain something to you.
Yes, ma'am.
From here on out, every decision you make, you need to ask yourself, is this a decision that could potentially result in me going to prison for 20 years? Do you understand?
Yes, ma'am.
I don't know anyone who looks at a blunt or a joint and says, wow, this joint is worth 20 years in the prison. You understand?
Yes, ma'am.
So if you need help with your drug use, then probation is here for you. But we can't help you if you don't ask for it, and we can't help you if you don't reach out for it. And we're not going to chase you down to try to get you help. You understand?
Yes, ma'am.
All right, would you go off the record, Brennan? All right, if there's nothing else, I'm going to send you to a breakout room, Mr. Shepherd, and probation will go over conditions with you.
All right. Thank you very much.
All right, you're welcome.
Thank you, Judge. May I be excused?
Yes.
I hope you have a wonderful day.
All right, thank you. You too. Guys, if there's nothing else, I'm going to stop the live stream. See everybody tomorrow at 9:45 because